All right, up about 20.5 points right now. The IRS, what do they say sometimes? Late than never, better late than never. Now, formally apologizing to Tea Party groups over this Obama-era targeting, they said those groups are saying was going on, to Chief Counsel of the American Center for Law and Justice and a member of Donald Trump's legal team, Jay Sekulow. Jay, I know better late than never, but they are acknowledging what was pretty much the obvious elephant in the room, that Tea Party groups were, in fact, targeted for their tax-exempt status. Now what?
Well, number one, I think this is what's significant here. It's not just that they're acknowledging the wrongdoing. They've taken action that'll be codified in a court order next week that it never happens again. So there's been a complete change of policy as it relates to the IRS. So there's been an internal change here.
Fines are being meted out. Right?
Well, out of the there's two series of cases. So the case in Washington, D.C., which is what we primarily handled, was the case involving the equitable relief. That's the declaratory judgment. That's IRS was wrong, violated the First Amendment, can't do it again, policies had to be changed. Then there was a class action case in Ohio, and in that case involved monetary damages. That case was we had one client in that, but we were not the class action lawyers. We worked with them. They did a great job. There's been a monetary resolution there for those clients. But so between both, you've got both a declaratory judgment that the activities of the IRS were not only unlawful and violating their own rules and regulations, but were unconstitutional, and new policies put in place and changes made through this declaratory judgment. And then on the other case, you've got damages as well. So the IRS, look, I'm very glad that the Attorney General, Jeff Sessions, moved forward to get this case resolved. It's been 3.5 years in litigation. We've had to make a trip up to the U.S. Court of Appeals for the District of Columbia to get the trial court judge reversed, which we were successful at. And the good news is also, which is the really bottom line here, is our clients all got their tax-exempt status. Better late than never, yes, and unfortunately it took 3.5 years of litigation. But, Neil, some of these clients, you know this, waited 7 years by the time they started till when they got it.
And really run through the rigors there in the process. But, you know, I always thought, and we probably teach our kids the same things, just fess up and own up to something right away. It was very, very clear they were targeting these conservative groups. And maybe at the time, for very good reason, the Tea Party was popping up 2009 and 10. A lot of them all of a sudden were applying at the same time for this tax-exempt status. I'm not besmirching either side, but just state the obvious. We had a disproportionate number here. We were looking at it. These were our focus. And by the way, we didn't like their methods or whatever. But just get it out there.
They didn't like their methods.
Because there was no mystery to it. They were doing that.
No, but here's the thing. I mean, the IRS, I was a Treasury lawyer for Chief Counsel's Office of the Internal Revenue Service. The tax-exempt division was our client. And let me tell you something here. They were asking for the names of donors of the organizations. They wanted to know what groups that the individuals had talked to, what politicians they have met with, what was the substance of their conversations. And on pro-life groups, they actually put out in a question that the opinions that you're advocating are not based on science. Now, how was that the IRS determination whether they could do that or not? And by the way, we had a great team of lawyers here at the ACLJ, but my old office mate at Treasury was also one of our lawyers. So a guy I worked with 35 years ago. So it was kind of a reunion victory against the Internal Revenue Service.
But, you know,
here.
you think about it, and believe me, I'm not, casting blame or credit on any side here. I am saying, though, that if you have this, all of a sudden, this phenomenon building, and they're all rushing to the door at the same time to claim tax-exempt status, what would have stopped the IRS at the time to say, yeah, we found this disproportionate, out of whack, and yes, we're targeting it? Because now it's very clear after the fact that's exactly what they were doing. They were going to far greater means to target these groups in ways that were not exactly honorable and applying litmus tests that did not apply to other groups. But they didn't do that, and they compounded the lie and the deceit.
Yeah, but here's what the IRS could have done. They should have followed their own Internal Revenue Manual. And they should not have determined exemption based on the political advocacy position that the clients were engaged in, which was a fundamental, and they've acknowledged it now, was a fundamental violation of the First Amendment, which is what they were doing here. So you look at the constitutional issues that were raised in addition to their own manual. There was a way to handle these, applications coming in. There's a normal process for it. I mean, there's an exempt division of the IRS, Neil, that knows how to handle.
But let me ask you about that, Jay.
501c4s. Obviously not.
I'm curious about that. Now, let's say there's a new party that forms protesting Donald Trump and whether he's taking executive overreach. I don't know. And they're going to call themselves the Coffee Party. I don't know. And they're going to start a lot of, tax-exempt
C4s.
Groups. Right. So where and how should that be handled?
It should be handled through an exempt process that does not deny their application based on the position they're advocating, and should not ask for their donor information. So the same rules that in the same case that we just resolved.
But why wouldn't donor information?
Well,
I see what you're saying.
America.
But why wouldn't donor information be germane? In other words, if there are some, nefarious types who could be behind you, and here you're trying to get a break from the taxpayer.
Well,
you know what I mean?
The Supreme Court. There's a Supreme Court decision that was argued by Thurgood Marshall and the NAACP Legal Defense Fund that said government agencies don't get your individual donor names. You know why? Freedom of association. You have the right to associate with others. You don't have to make it public. That goes past, Thomas Paine. I mean, it goes way back.
So whether you're getting a tax break that avoids paying United States taxes or not.
Yep. You don't even the NAACP was tax exempt. The NAACP Legal Defense Fund was tax exempt in the 50s. The state of Alabama wanted their donor list, wanted their membership list, and the Supreme Court said no, you don't get them.
All right. Switching quickly to this dossier and then this whole Uranium One deal. The one common theme that gets pounded again and again and again is the idea that the Russians might not have taken sides as much as great interest in screwing up our election or really screwing up the powers that be in both parties. What do you think?
I think, look, the Russians were trying to do something on this. Fusion GPS was involved. Apparently, now that we're hearing, Fusion GPS, Christopher Steele was dealing with Russians on this in this unverified dossier, and it became, the government better hope that this was not the basis of those FISA warrants either. If the underlying information coming out of this dossier for Chris Steele served as the basis for which they went into the FISA court to obtain warrants that were later unmasked, and it was based on that information, you're raising a whole host of constitutional issues here. So I think, look, there's going to be hearings on this now. Information's coming out. There's a lot of questions to be asked, but until those hearings start, you're not going to know all the answers. But I will tell you something. Obviously, something was afoot here.
Do you think that the FBI is going to be as aggressive getting to the bottom of this as it was to anything hinting of collusion between the Trump campaign and the Russians?
Well, they better be. I mean, you can, equal justice under the law. So, I mean, they need to investigate this thoroughly. They've got information now. Look, Fusion GPS's leadership, when they were called before the House and the Senate, took the Fifth Amendment. They have the right to do that. I would defend their right to do it. They have a constitutional right to invoke the Fifth Amendment. They did it. They're now fighting the subpoenas that were issued for their bank records because the bank records probably show where the money went and how it was flowed. That's going to be litigated in court. But I think Congress has now got oversight capabilities. You should have an ongoing. I would think that the FBI would be investigating this now. The Federal Election Commission may need to take a look at this on the way that money was reported. So there is, again, a whole host of both statutory issues here, criminal law issues that can be implemented. And I think we just are seeing the beginning of that.
All right, Jay, it's always good having you. Thanks for taking the time.
Thanks, Neil.